Sorry, I'm not going to do about it.
I'm going to put you guys in the waiting room.
Okay.
Going in the way.
Rita, what's the delay?
I'm waiting for Mr. Mari. Apparently, Mr. Deal was using the old. He's here now, but they were using that they were expecting a new link, but
Gotcha.
they've been notified to use the old link.
Okay.
And in the meantime, I'm just showing Joy how to do the live YouTube.
Okay.
stream.
Well, I mean, I'm obviously keen to start. So how much time are we talking about?
You can start now, and then I can.
Am I in some sort of a waiting room, or is this,
Everyone else is in the waiting room.
well, can you bring them out so we can start?
Yes.
All right, thanks.
You put the video. Sorry, thanks.
Okay, good afternoon, council. I did ask Ms. O'Connor to bring you out of the waiting room, just given the hour, although I understand that we've been waiting for Mr. Mari to sign back in because of some confusion as to which sign-in code, which passcode we were using. I don't know if that accords with everyone else's understanding, but
I just used this morning's link. It's worked fine.
okay. Does anyone have a WhatsApp or any sort of text message from Mr. Mari that he's signing in now, or?
I just emailed him and told him to use the morning link.
Okay. Well, I think we
I'll try
should
and call him.
Can we
probably continue, but
can we press on? If I,
yes, I think we should. Thank you.
on that topic, my lady, I think I should raise this issue with you now.
Yes.
With the best, unfortunately, I've tried to be as quick as I can, and with the best will in the world, realistically, I'm not going to finish all of my submissions. Have my learned friends make their submissions, have me make submissions in reply on the law, etc., before close of play today.
Okay.
I don't know what your ladyship's diary is like tomorrow. I suspect you're doing chambers.
No, I don't, but I was using that for a day to try and deal with the judgment.
Well, I mean, obviously in your ladyship's hands. My suggestion in any event, and I think it will meet with my learned friend, Mr. Horseman's approval, is we plow through, we will finish my submissions today.
Okay.
And then my suggestion would be we adjourn to a date as soon as possible.
We should definitely identify the date this
Yes.
afternoon. There's
Yes.
no question about that. That should be fixed.
That's all I'm thinking is perhaps we just use today to get through my submissions.
Okay.
I am trying to be very fair. I think one thing I personally hate is starting my submissions and then coming back in 4 days and in the middle of them. And I think it might be fair to both my friends if they would then
Have a clean start of their own submissions.
Exactly, and then I
Okay.
can deal with
Yeah.
reply.
Assuming that that is an agreed
Yeah, that's fine, my lady.
request. Okay. Let's just look at the calendar first for a moment since I have it open. It may be that we may have to come back tomorrow because for me, a lot depends on whether or not there's a trial that I was due to start, a jury trial is due to start on the 20th of September.
Right.
And it appears that that may not in fact go ahead on the date.
On that date.
Right. So
Sorry, my lady, go ahead.
if that is the case, I would probably look to do this on Thursday, the 23rd, or even, what are we looking for? Another half day or another full day?
I think to be safe, my lady, I think, I don't know, sorry, I haven't discussed it with my friends, but I think to be safe, a full day.
Okay.
Because I don't want
That
to,
would, I
Sorry?
mean, my view is, Mr. Deal's gone through the facts and a lot of it's not contentious factual wise. A couple of issues. I would think I would be no more than an hour and a half.
Well, I had an impression somehow, Mr. Horseman, that the real weightlifting was going to be the submissions made by Mr. Dill. And I mean, now I've been taking through so many of the documents, I can see from your written submissions what your emphasis is likely to be.
Yes.
And I'm not sure. I mean, I said, Mr. Myrie, can you weigh in on this, please?
I'm not sure Brian was here for the whole of it.
No, he's here. I can see his.
oh, you can see his forehead.
Yes.
Sorry, let me just move it down a little bit. Right, so my submissions, I think if I understood correctly, the PSC was going to go first. And obviously I don't want to duplicate anything they might say because a lot of our submissions kind of dovetail.
Mhm.
So depending upon how Mr. Horseman brings things forward, mine was just really to clarify the government's position.
Yes.
Right?
Yeah, I mean, basically, I'll take the same position on a few things. So, and I'm not going to be going back to the documents, my lady. You've been through them. I might, if I highlight 2 documents, that's going to be it.
I mean, that's helpful because I have to tell you, I have a preference. We're going to come back. I have a preference to do it on the 24th, Friday, the 24th in the morning and do that as a half day. I do have a matter that's set to go in the afternoon. And I am going to give priority to that matter.
I would think it'd be fine on the 24th, aside from it being my birthday, but I'm not planning to go out in the morning, so I can make it.
Well, it's only 2 shopping days before mine, so
Okay.
I think I'm going from memory, lady, but I think that works for me if it works for both my learned friends.
And I'm
Yes,
sure
24th
it's a half day.
Have to-
24th is fine for me.
Okay.
So, well, my lady, subject
So
to,
you can just finish up your submissions this afternoon.
well, that's what I was planning. Yes, ma'am.
And then I can
Then we can have,
adjourn
as
at
you
that
say,
point for
fresh start.
the
Yeah.
responses to come on the Friday.
Yes.
Okay.
make this point, I will have to be in reply in any event, my lady, just on not a criticism of my friend at all, but he sent some authorities through, which I really need to hear how he develops that argument so I can respond to it properly. Just if I just flag that up. Another bit of housekeeping, my lady, over the break, my friend Mr. Horseman sent to I believe your clerk a copy of the letter of the 29th of August of
Yes.
2018, the one I was pontificating
Where
on.
is that letter?
Where is
Yes.
it?
Yeah, where is that letter?
Here it is. Here it is. I have to say, and again, not a criticism of my friend, because he says, and I have no reason to disbelieve him. He says he thought it was sent. We can't find that it was sent, but I'm sure it wasn't deliberate, and I make no more of it than that. Does your ladyship have the letter?
Yes, I do.
Sorry, this is the first time I've seen it, but perhaps I can deal with it very quickly this way.
Mhm.
You will see at the very beginning in italics on page 1, Mr. Lorty deals with the decision that was made by the PSC, and then he goes on at some length for the next 2 to 1.5 pages, dealing with concerns that he has as a result of his investigations. And suffice it to say, if we haven't seen this letter until today, you may rest assured that our client hasn't seen this letter at all, nor the contents. But in any event, my lady, what is interesting, and it's just the point at the very last page, where he says, my recommendations are, Roman numeral 1, abort the current recruitment process. So, and we know the answer, what the answer to that was, because the PSC, in spite of all this information, said, no, we're pressing on. So that is a bit of a storm in a teacup, or it should be, and it doesn't lie in their mouths to try and rely upon this report now, having made a determination.
Perhaps I could just assist my lady. I mean, if you go to page 20 of the correspondence file, 21, 22, maybe the confusion lies. The minutes are almost verbatim of this letter. So there's nothing new or surprising.
No, that's why I say I wasn't, that's why I said, sorry, to make it clear, I wasn't making much ado about this letter at all. There's no smoking gun in the letter at all.
Yeah, I was just saying, when you said, where is the letter? I wanted to produce it.
Well, now we see the letter.
I mean, if you look at page 22 of the correspondence, he said, Mr. Lordy gave the following recommendation to board the
Yes.
process. So it's not like this hasn't been out in the open.
No, I totally accept that. So it's better late than never, is perhaps the way to put it. Can I go then back to my friend's submissions, my lady? I was
Yes.
plowing through them. I think I left it at, should have made a note where I left it. I think paragraph 19.
That's my last marking, yes.
I'm grateful, my lady, thank you. Yes, we have more statements by my learned friend that the PSC, 4 lines from the bottom of that paragraph, was not satisfied at the time of deferring the decision that the applicant was suitable for the post. Well, firstly, that's not in the minutes. It's only stated in the affidavit of Carlita O'Brien. And if she wasn't suitable for the post, why was she being put in an acting, being, quote, recommended for an acting role? Then paragraph 20, where my friend is developing a rather sort of altruistic argument that they were basically, if I can put it this way, trying to save the applicant from herself. The PSC also considered that if the applicant was appointed to the post, there was a real risk that the applicant would not have survived the probationary period. and she would have been at risk of losing her employment altogether. Well, that again, save for the appearance in Ms. O'Brien's affidavit, that doesn't feature in any minutes. And it is, again, in my respectful submission, ex post facto rationalization. And while we're on that, let's look at the extract that my learned friend provides. See Regulation 21.5, which provides as follows. Where any appointment to an office is subject to probation, the Commission may at any time before the period of probation has expired, either on its own motion or at the instance of the head of department. Well, this is the head of department, so the only way it could be would be on its own motion. And then interestingly, recommend to the governor that the appointment be terminated forthwith. So once again, we have examples of recommendations that should be made to the governor, and just the governor, as my friend himself accepts later on in his submissions, was just completely absent from all of this. Moving on to 22, I don't think there's anything in 21. Yes. The last sentence, the course that the PSC adopted was with the applicant's best interest at heart, namely to ensure that the applicant did not lose her employment altogether.
Well, that's what you just dealt with, isn't it?
Well, yes, I'm wrong. But my only point on there, my lord, is just, that's not their job.
Mhm.
That is not the PSC's job. Then 23, this actually makes our case for us. The fact that the applicant may have been required to undergo the same process twice cannot amount to an unreasonable decision. The applicant could have been required to undergo a second stint of probation, even if she had been appointed to the post. And then my friend cites the relevant regulation, which grants the PSC the power to order that the period of probation be extended for such further period as the Commission may specify. So why on earth have her in an acting role when they themselves accept that if they had substantively appointed her to the position, they could have done exactly what they were doing now. She would have had automatically the 6-month probation, and they have the power to extend it. That makes our point for us. Yes, so then at the bottom of the page, the complaint that the applicant would in effect have to undergo 2 6-month probationary periods is without merit. Well, their recommendation is without merit. It's illogical and unreasonable. And we've just covered why. And then if we can deal with down at the bottom of the page, my lady, the delegation point. The applicant argues in paragraph 18 of the grounds of relief that there can be no delegation under section 83(1) of the Bermuda Constitution Order in relation to the offices of permanent secretary or head of department. And our client would be the head of department. The applicant contends that the delegation of authority, the head of the civil service, under the Public Service Delegation of Powers regulations, must be read as excluding the office of Director of Parks. The applicant then concludes that the PSC's recommendation is therefore its decision to have the applicant, the applicant then concludes that the PSC's recommendation was therefore its decision to have the applicant act in the post. I don't quite know what that means, but I think I understand the gist of it. But the fact of the matter is, my lady, what my friends quite interesting and relying on is regulations that specifically provide for delegation of powers. Well, who would those powers be delegated, assuming the regulations do what my friend would like them to do? The delegation must obviously be coming from the governor. Section 83 is crystal clear. And sorry, section 83 and section 82 combined are crystal clear. There can be no delegation of the governor's powers, period. if I've been using the colloquialism, the Constitution trumps this. Or put another way, perhaps more
I mean,
elegant.
I understand your submission. I have to be honest, maybe Mr. Horstman will make good the submission that he makes in this paragraph. I'm not quite sure whether or not I'm reading it
Well,
as he intends me to.
yes. Well, firstly, lady, any regulation, it's trite law that any local, if I use this way, local legislation must be read so that it's consistent with the Constitution.
Well, yes.
And that's it. So where the Constitution says in terms,
Mhm.
where we're talking about the
It's
appointment
supreme
of
law.
exactly.
If I can get the bit, but I'll save it for when I do my submission.
Well, then, I'm trying to deal with my friend's written submissions, and we'll see what my friend has to say. But the very simple fact of the matter is the public service regulations cannot override the Constitution.
Well, if it is this, I'm happy to make the point now, my lady.
I mean, if it will dispose of it quickly,
Well, it might be. The point that's being here is the PSC deferred the decision and said to the head of civil service, the PS, you put her in an acting position, we'll assess her over the 6 months and then come back. The delegation of powers says it's for the head of civil service to appoint an acting position in the director, as long as it's up to 6 months. So that's all this is saying, that the head of civil service, Hawks, has the power to make an acting appointment up to 6 months.
okay, that's probably going to be a longer submission.
Yeah, okay.
So let me,
Sorry, lady.
yes, I was just going to come back to you, Mr. Deal. I think I'll let you, I'll see how Mr. Deal handles that, and then I may have to hear you fully on that.
Well, let us start from first principles. The regulation that my friend relies upon is this, that the power must be delegated to his argument to the head of the civil service, yes,
Yeah.
from someone.
Mhm.
Now, who is that person that it's delegated from? The answer is the governor.
Mhm.
Now, under
The governor
section,
can't delegate his powers. It's still under the Constitution.
it
Section
says so
86.
in black and white. It doesn't say, for example, he can't delegate his powers brackets except for acting appointments. It doesn't say that.
Mhm.
It just says he cannot delegate powers to deal when you're dealing with, in this case, the head of a department.
Yes,
And
that's the substantive appointment, sorry.
no, it makes no difference, and this is my point, my lady. It makes no difference whether you're talking about a substantive appointment.
Well, this is
Or-
what I was asking you
or
earlier
acting
in the
appointment.
hearing, and I think you've addressed me on it. And obviously, it's a point of contention. I'll have to hear arguments. Let Mr. Horstman spell out his
It
submission.
would literally have to read something along the lines of you can't delegate any powers brackets except for acting powers. But it says in terms there can be no delegation, and it says it crystal clear in relation to section 82. I think it's 82.2, which deals with head of department. Also, it doesn't get my friend home anyway, because you'll remember in any event there's still the duty to consult with the premier.
Mhm.
So my friend doesn't get home in any event on that. Now, what they tried to do is just delegate everything, all goes over to the head of the civil service. And the mere fact that they've been doing it wrong for possibly decades is not a good excuse. Paragraph 28, my lady, I made these points before. PSC made a recommendation. Who didn't make a recommendation to? Certainly wasn't the governor. Yes, my friend makes a point in 29. Yeah, we've covered that. In 29 about the delegation. There's just it doesn't exist. Much as my friend would like it to exist, it doesn't. Yes, there's more of the same over in 30 and 31, and I've made those points already. Sorry, Melanie, I'm going as quickly as I can.
Yes, that's fine.
Yes, as said, now this is I've mentioned this before, but I think I should mention this point again. I didn't quite deal with this paragraph on this way. I took you to this paragraph earlier. As set out in paragraph 12 of the second affidavit, once PS Randy Rochester withdrew the application for the post and withdrew the recommendation, I don't know why, and withdrew the recommendation, I presumably means withdrew somehow the interview panel's recommendation, which Mr. Rochester wasn't even involved with. The PSC had little alternative but to accept his recommendation. I think that's recommendation to, I don't know, but perhaps my friend can assist on that. Mr. Rochester had indicated that he tried to find a resolution to the difficulties faced, but in the end, he was unable to find a viable way forward, which resulted in the PSC accepting his recommendation. I think that means his recommendation to withdraw the application. But they couldn't do, milady, and what you will notice was conspicuous by its absence in any of this is how my friend tries, or what my friend doesn't deal with the operational necessity point. Sorry, I'm grateful to my friend Ms. Rich. I misspoke. Apparently, Mr. Rochester was on the original interview panel, so I withdraw that comment. But there was no, given that there was an application made, and there's no doubt the operational necessity for this position to be filled existed and continues to exist to this day, on what basis could it properly have been withdrawn? There's only two ways it could have been withdrawn. One is to say it's no longer an operational necessity, which you didn't say, or alternatively, we just don't have the money to fund the position. You remember I took you to that.
I was going to say you've dealt with those points.
I've dealt with it
early.
Yeah.
Yep.
At paragraph 33, we completely disagree. There ought to have been a substantive appointment. Paragraph 37.
Mm-hmm.
So it is clear from the contemporaneous document the applicant was not offered the post outright. The most that we said was the PSC would reconsider the appointment following the implementation. This was confirmed in an email. This argument, my lady, respectfully, misses the point. The simple point was the PSC ought to have recommended to the government. So sorry, got me doing it now. Recommended to the governor that she be given the substantive post. And then interestingly enough, this is where you see this error creeping in. Good day, Terry Lynn. This is from the acting PS. What I was told is that after a 6-month period, the PSC will determine if they are satisfied and if most of the issues have been addressed. If it is positive and they, that's the PSC, appoint you to the post, a probationary period will still follow. Paragraph 38, third line, what is clear is that no time was the applicant offered the permanent post, quite right, and that's entirely our case, it ought to have been. And then final sentence there, so putting the applicant's case at its highest, it might be said that she had a legitimate expectation that she'd be able to participate in the development plan. So, no, because the whole scheme was ultra vires. This was cooked up with the wrong people. This needed the involvement of the governor. Never had it. Paragraph 39. It is for the third respondent to explain the reasons why the application was withdrawn. Well, respectfully, no. The PSC should have asked why it was being withdrawn. But it seems evident from Mr. Rochester's affidavit that in the event the applicant was appointed to act as director, the Department of Parks would have had a wholesale mutiny on its hands backed by the unions. Well, simple point, she's acted 5 times since then as director, and we haven't had wholesale mutiny. Paragraph 40, very
You took me
concerning.
through 40 earlier this morning.
Yes, the only point I want to make here, milady, is that here's the unfortunate point of the PSC
Mhm.
trying to shovel blame, as it were, on the duty to consult. Because what they're saying is, however, the applicant was consulted and still had the opportunity to persuade the PS to change course. But it's the PSC who should have had undertaken.
Yes.
Thank you. Paragraph 46, 4th line from the bottom. My friend accepts the point that the governor had no role in this matter at all, as the PSC never forwarded a recommendation for the governor to consider. And that deals with that deals in part with my friend's submissions. If ever there was a case, this is on the section that starts at page 14 on discretionary remedy, as if ever there was a case of someone wanting to have their cake and eat it too. Firstly, they say, oh, this case has taken 2 years to come on, and for a variety of reasons, not least of which would be the problems of, I'm trying to find his section where he says it, but 41? Thank you. No, it was a different, there's a point in my friend's submissions where he basically says, given all the ruckus and the upset that has happened, it's just a bad idea to have her appointed to this post. And basically saying, you really shouldn't be fixing it by way of a mandatory injunction. But in the same breath, he then goes on, or in the next breath, I should say, he then goes on to say, oh, and you can't get damages as an alternative remedy because you
Yes.
don't have a
private law cause of
a
action.
private. Well, there's a very simple point to be made on that, and I can take you back, but I'll merely refer your ladyship to the case of McLaughlin, which is set out. We set out the head note, and I'm not going to take you through it. I had asked your ladyship to read it.
Yes.
In our submissions, we set out the whole head note. But the simple point was in that case was where there was a civil servant who had been wrongfully terminated. And
Yes.
under his contract of employment, he would have been entitled, if we were talking about wrongful dismissal, to 3 months notice in lieu of 3 months payment in lieu of notice.
Mhm.
That was what he was, quote, contractually entitled to. But the Privy Council didn't do that. What the Privy Council did, and it was, if I may say, the sensible approach, was to say, we are going to make an order that his termination was ultra vires. Now, what flows from that? What flows from that is he should be paid, or should have been paid, for the last 7 years. And he should be paid up until his retirement. So that's what they did in McLaughlin. If my friend's submissions had any validity, the Privy Council would have simply said, oh, you're entitled to the contractual amount as, quote, damages that you would have got or would have received for wrongful dismissal. They didn't do that. So what we're in an interesting situation here because we are the mirror image of McLaughlin. We are saying that we should have been appointed. And we are saying in line and consistent with the McLaughlin authority. The question is what flows from that? Now, perhaps mea culpa, maybe, I characterized it as damages, but put another way, it's consequential relief upon the court making a determination. So just as in McLaughlin, That is what we are seeking. So the court, first of all, has to determine what, if we are right, what ought to have happened. And we say she ought to have received the substantive appointment. And what flows from that, what is the consequential relief that flows from that? And that is entirely consistent with McLaughlin. And what my learned friend has done, if I may say, and rather cleverly, is to engage in basically a red herring and saying, oh, no, this is all tied up. You have to have a pre-existing claim in damages. No, you don't. McLaughlin says you don't. So that deals with, and so I would ask your ladyship to look at, and McLaughlin as a Privy Council decision obviously is binding on your ladyship. And that approach is exactly what we are seeking in this case. The only difference, and it's a difference without a distinction, is that in the McLaughlin case, he had an existing contract, but it didn't matter because they held he was entitled to, as a consequence of the ultra vires decision, he was to be paid going forward. We are seeking exactly that situation. We are saying we ought to have been employed, we ought to be in that position, and this is a consequential relief that we are seeking. Then finally, milady, as far as, I say finally, as far as the my learned friend Mr. Horseman's submissions, a very concerning paragraph, if I may say, and I have to commend my friend for his candor. But this is what he says in paragraph 51. If the court was minded to grant some financial remedy, then any award of damages should be limited to the remuneration the applicant would have expected to receive for the 6-month acting period while the development plan was to take place. It is extremely unlikely that the applicant would have been appointed to the substantive post given the feedback received and the strong opposition to her appointment. It cannot be, and this is my friend is making this submission when we have provided, by this time, we've provided the PSC.
Yes, the
with
whole
the
history.
performance support, with Dawn Santucci, whatever her name is, sorry, her affidavit.
The employee, yes.
The employee, yeah, all of that material. Here is the PSC through my friend, and obviously they must have approved these submissions. It is extremely unlikely the applicant would have been appointed to the substantive post given the feedback received and the strong opposition to her appointment. Why? She's acted for 5 times since then as a director albeit of another department, but it makes no difference. And then the rather ominous comment, it cannot be forgotten that the applicant, had the applicant been appointed to this substantive post, it would have been open to terminate the applicant for any reason during her probationary period. So any claim for financial loss would be speculative at best. If ever there was a veiled or not so veiled threat, it's that. And what is of great concern to our client, she raised this herself, is the fact that here is the PSC who determined, on the basis of completely improper exercise of investigative procedure, that she was not suitable for the position. And now saying, basically, there's not a snowball in hell's chance that she's going to be given, she would ever make it through the probationary period. How on earth can our client go back in front of the PSC in the future for any application, for any position, given that the nature of that statement made by the PSC? It is the most obvious statement of bias by predisposition.
So tell me, how do you invite this court to calculate her
The damages we've, and that is why we've said, and I, again, maybe my phraseology was unartful, anyway, was not artful. Well, what we're asking for is I call it an inquiry into damages. And another way to put it would be an investigation into consequential relief or a hearing on consequential relief.
Okay.
What we would suggest is we would say that she should have been given the position, and as a result of which she should receive in line with the McLaughlin Authority, the difference between her current salary and benefits and the salary and benefits that she would have received as.
But that's something I would do within a separate hearing for consequential relief if we get that far.
That would be my suggestion, my lady. Yes, that's why we put that in the submissions.
Okay.
Because obviously, if for whatever reason, and I hope if for whatever reason you don't agree with us, we don't need obviously to go through that exercise. But if your ladyship is with us and saying, yes, she has been treated unfairly, yes, she should have been substantively appointed. Because the problem is now you can't say, or it's very difficult for you to say, thanks to what the PSC have done, they've burnt their bridges, because you can't say, well, I'm going to order that this go back for a rehearing or order them to reconsider it, because they made it abundantly clear. And that's why I use the phrase bias by predisposition, that she's not going to make it through the system as far as they're concerned now. Never mind the merits. So, ladies, can I then move to the AG's submissions?
Mhm.
And I don't think I need to. I've already taken you at page 4 to paragraph 2. Oh, you've now located those submissions, have you,
Yes,
Melanie?
thank you.
Okay.
Mhm.
I've already taken you at page 4 to. I don't think you had it in front of you, but if your ladyship
Yes,
sees
that, so
paragraph 2,
you asked me to mark out page
I did.
4, paragraph
paragraph 2, my lady.
2. Okay,
It's the starts for the board bit I submit.
thank you.
There was no recommendation ever made to the governor. If your ladyship can go, sorry, mine is, I think it's page 5, over to paragraph 6. This, again, respectfully, I think misses the point. My friend says, similarly at paragraph 7 of the grounds, the applicants state that regulation 21, the public service states that every appointment to an established office will be subject to probation. Then he goes on, was not acting for several months, but that's not the point. The point was if she was going to be appointment to an established office, then it would be subject to a period of probation. It's not the temporary post point we were concerned about. The point there is if she's appointed, it ought to have been appointed by the PSC to substantively, then in any event, and this is the point we're making, there would be a period of probation, and that period, as set out in the regulation, is 6 months.
Mm.
And as my friend Mr. Horseman accepts, that can be extended. Then we go through Dolding, which is really respectfully just not relevant, but wait till my friend develops it. Then under the heading communications with the permanent secretary, the applicant's, this is rather interesting. The applicant's claim is misconceived as the ministry has no power to appoint the applicant to the post. Well, certainly according to the excess of the evidence, they were trying to do exactly that, albeit as an acting position. And if that was the case, then why was the PSC making recommendations to the ministry or to the head of the civil service? And then last line on that bottom, the governor did not receive any recommendation from the PSC. Paragraph over the page to page 6, my lady. This is the comment. This is the submission I commented on earlier this morning. The PSC is also free to receive information in regards to any matter they see fit to assist them in their deliberations. That is not correct, my lady. They can receive information in relation to any matter to assist them in their deliberations, but it has to be subject to the
Constitutional principles of natural justice.
Indeed. And in fact, I've taken you to the government's own code of conduct, which sets that out. So
Yeah.
that's just not correct.
Mhm.
And then over the page to paragraph 6, it's where your ladyship will see paragraph 60.
Mhm.
The,
Yes.
the principle that
Mhm.
the principle that a decision maker or a tribunal, this is our point, is allowed to determine its own, emphasis on this word, my lady, fair procedure. Was there fair procedure in this case? Simply put, this is setting out, by the way, this is from the Tucker appeal case.
Yes.
So was there a fair procedure in this case where the applicant was kept deliberately in the dark as to all these complaints and concerns being made against him? And then paragraph 66 of the Court of Appeal decision, they held it was a fair process. This, just so we're clear on that, lady, the Tucker case was where the PSC accepted the recommendations of an interview panel that had not been put together in consistent with the PSC's own regulations. And in that case, there was evidence filed by members of the Board of Education to say that we received the recommendations from this improperly constituted panel, but we were okay with that. That was sufficient for our needs. We didn't need to make any separate inquiries. So the Court of Appeal held then, whether I agree with it or not is neither here nor there, that was a fair process for garnering the necessary information for the rendering of their recommendations. I'm reading from paragraph 66, and did not constitute an improper delegation or abdication of the functions of either the Board of Education or the PSC. We're not in that situation. We're in a situation where the PSC embarked on its own investigation, excluded the applicant from being able to comment or make any submissions on it in her defense, and then acted on it. So my friend then at the end of that says, again, same situation in this case, respectfully not. The PSC relied on information provided by Mr. Farrow, Lorty, and Rochester, that's quite correct, but came to its own determination in deciding to withdraw the opportunity to allow the applicant to participate in the plan. Well, somebody hasn't got their story straight, because if you just had me take you through my learned friend's submissions, where he states that the PSC had no other option but to accept the recommendation of Mr. Rochester, and when he withdrew his paragraph 32 for your ladyship's note. It's completely inconsistent with what my learned friend Mr. Horseman is saying happened. And if it came to its own determination in deciding to withdraw the opportunity to allow the applicant to participate in the plan, it did so because they withdrew the application. And we have all the business about operational necessity, which your ladyship has heard before. Yes, following meetings with the managers, 40, this is paragraph 14, bottom of the page. Mr. Rochester had genuine concerns because the board's reported management style not fit for the appointment of director, and therefore was open to the PS not to recommend the applicant for the appointment until it was assured the challenges surrounding it could be overcome. This was reasonable in the circumstances and did not amount to, well, we covered that, why you have 2 periods of 6-month probation is a mystery, and it's not explained. Over the pages to page 9.
Yes.
Again, somebody hasn't got their story straight. Paragraph 34. The applicant produces a copy of the plan, which the applicant provides as support for her assertion that she was offered the post of director. While the plan refers to the post of director, it refers to the post's projected post title. The plan confirms that the applicant was not offered a permanent post at the time, but the applicant was offered a conditional post of director dependent upon successful completion of the plan. That is not what my learned friend Mr. Horseman has said. And then my friend adopt paragraph 35, adopts the applicant's statement. In essence, the appointment was a conditional appointment. It's all this mess, my lady, this ball of confusion. Can I just have one moment, Lynn? From 35. Yeah. And at paragraph 38, my lady, they make the same point in another way. What was offered was the applicant would act in the post for a 6-month period, and if the applicant successfully completed the plan, she would be appointed to the director post for the further 6-month probation period. Why are we going through this exercise? Oh, sorry, my lady. Yeah. My lady, those are my submissions at this stage.
Yes.
Unless you have, as I say, I've got the extract from Lewis there, but I think it's probably best if I hear my learned friend first on those type of points, and then deal with that as part of my reply.
Yeah.
Unless I can assist your ladyship any further.
No, I think that was very helpful. Thank you. And I'll just try and get a grip on these documents in the interim period.
What I think we might do, my lady, if you approve, is to send someone up and insert these authorities and the extracts into our.
That would be very helpful.
And then we'll,
I have to say the loose leaf is.
Yes, so you're all
not
over the place.
convenient.
And then we will give you an amended index as well.
Okay. Yes, thank you.
Thank you.
Unless it presents any sort of cost concerns for anyone, I think that would be
No.
helpful. Yeah. All right, so I suggested that we would continue. What was the date I gave you? Was it Friday? the
24th September, my birthday.
You keep mentioning that, but just this.
That's fine, my lady, I'm good for the morning.
We all have birthdays.
As long as it doesn't run into the afternoon.
As long as you finish by lunchtime, that's what my learned friend is saying.
Well, I mean, he'll be happy to know, like I said, I do have a
Yeah.
2:30 matter.
It will finish by lunch.
I do want it to proceed, so,
Yes,
we really are
we will.
confined to the
We'll
morning
finish.
session.
We will, my lady, yes.
Yes.
Yeah, I just see there's a few points in issue. And
All right.
my
So-
friend's hopefully gone through all my submissions already.
Yeah, it's a very forceful style of advocacy.
Sorry about that, my lady.
And so I'm going to adjourn for continuation to Friday, 24th of September. It's the day before my son's birthday, as we're talking about birthdays.
Oh, all the best of us are leaving.
And-
so.
Thank you. Let's do 9:30 to play it safe.
Thank you, madam.
Yes, at 9:30 a.m. Okay?
Thank you, Melinda.
Thank you very much, madam.
Thank you,
Okay,
my
thank
lady.
you. And have a good weekend, everyone. Thank you.
Yeah, thank you.
When it
Bye,
comes,
lady.
actually.
Yeah.